We'll then pass on to our next case, which would be DIANDERAS versus Florida Birth-Related Neurological.
Negligence.
Let's take a look.
Somewhat disappointed.
Appreciate your keeping an eye on it.
Judge Ploys also has it. Good morning.
Morning, Counsel.
Good morning. May it please the Court?
Whenever you're ready.
I'm Scott McMillan, counsel for the appellants. I'd like to reserve 5 minutes of my time for rebuttal and to reply to the cross appeal, which I would not address during the first portion unless the Court would like me to. We have raised 2 issues on the appeal. Our primary issue is that the contents of the NICA brochure are inadequate under the law. Our second issue is whether the administrative law judge erred below by excluding the testimony of Mr. Ronald Gilbert, our expert witness on that matter. At this time, I'd like to state that we would like to withdraw our point 2 issue dealing with the testimony of Mr. Gilbert. We don't believe that the case really turns on the admissibility of his testimony, and my clients would not like to win on point 2 and have the case go back down and be reheard, only to come back perhaps a year or 18 months from now to get a chance to argue on point 1, which is the central issue in this appeal. So as to point 1, our argument is that Section 766.316 Florida statutes, which is the part of the NICA statute that requires prior notice to these mothers about the NICA program, it says that if the obstetrician is a participating member in NICA, and not all of them are, it's optional, but if they are, what that statute requires then is prior to the delivery of the baby, both the physician and the hospital shall give the patient notice of the NICA program on a form. And the form shall contain a, quote, clear and concise explanation of the patient's rights and the patient's limitations under the plan. The statute goes on to say that this form is to be prepared by the NICA Association, and what they've come up with is this brochure that's called Peace of Mind for an Unexpected Problem. Now, that brochure has been around for a while, and there are different versions from case to case with minor changes. The one we're dealing with is the one that's in the record on this appeal, and that's the only one we're dealing with. In the case of Galen versus Braniff, the Supreme Court was looking at Section 766.316, the notice statute, and what the court said was that the obvious purpose of requiring this notice is to allow the patient to make an informed choice between staying with this obstetrician and then going under this NICA plan if a bad event occurred, or preserving her common law rights by switching to another obstetrician. The court in Galen also noted that the legislative task force that created the NICA program certainly recognized that the failure to give proper pre-delivery notice about the situation to these parents would subject the entire NICA program to constitutional challenge for lack of due process. And this brings me to the central issue, what are the rights and limitations of the patient under the NICA plan? To answer that question, first let's look at what the rights are. It seems pretty obvious that the rights or the substantive rights under the NICA plan are the benefits or the compensation that the family can get under the plan. Conversely, it seems like that the primary limitations under the NICA plan are what they can't get under the NICA plan that they might otherwise be able to get if they weren't under the NICA plan. The brochure lays out the patient's rights, or what they get under the plan, pretty clearly and concisely, like it's supposed to. It's in a section entitled Compensation, and under that it says, under the plan, the patient may recover. Then it goes on to list categories of things: reasonable and necessary medical care, services, travel, things like that, economic categories of damages. But what's missing is, where's the explanation of the limitations under the plan?
But doesn't it say that the award is capped at $100,000? I mean, that's the financial cap or limitation under the plan, correct?
That is an award to the parents. That's not discussing the award to the child. Under the NICA program, what you get are certain economic categories of damages for care, which actually is money that goes to other people for taking care of the child, and the parents, not the child, may recover up to $100,000, and the plan doesn't actually say which damages were the parent is supposed to compensate. But all it says about the limitations, or what the parents can't get under the plan, is just two lonely sentences. It's under the section that says exclusive remedy, and here's what it says: the law provides that awards under the plan are exclusive. This means that if an injury is covered under the plan, then the child and its family are not entitled to compensation through malpractice lawsuits. What's wrong with that? First off, that's really just a procedural limitation. On the one hand, the brochure says you can't get compensation from a malpractice lawsuit, but on the other hand, what it's telling them is, but you can come to us. You can come to this administrative procedure, which is described as a no-fault procedure, for compensation as an alternative.
So, counsel, what would you have the brochure say?
I would have the brochure say something as simple as, and I've actually tried to give a couple of suggestions, and I'm not saying we have to rewrite it for them completely, but I would have it say something like, under the NICA plan, there are elements of damages which may not be compensated, but which might be compensated under a medical malpractice claim.
And you think that is somehow substantially different than, this means that if an injury is covered by the plan, the child and its family are not entitled to compensation through malpractice lawsuits?
I think it is very substantially different, Your Honor. And I would add one more sentence to that explanation, which is, these include such things as compensation for lost future earnings and compensation for things like intangible damages for pain and suffering, mental anguish, disfigurement, and the loss of capacity for enjoyment of life. This is the substantial limitations under the NICA plan. That's what's important to these families, that there is a huge difference in what they can get under NICA and what they can get in a common law malpractice case. A huge difference. And these babies, by definition, if they fit in the NICA program, they started out healthy. They're term babies by weight. Congenital defects aren't covered. They are babies who come into the hospital for delivery, and then during delivery, a monitored delivery in a hospital, they suffer such serious oxygen deprivation or mechanical trauma, such as crushing their skulls with forceps, that they are rendered then in the hospital profoundly brain damaged. The statute by definition requires these children to be in the program, have both severe and permanent mental and physical impairment. These children will never work a day in their lives. They will never walk. They will never talk. A lot of them are on ventilators. The substantial limitation under the NICA plan, as far as these families are concerned, is that they don't get their full rights to common law rights to compensation for these injuries that occur in the hospital during labor and delivery. That it can't be denied by the appellants or by their lawyers that as far as the families are concerned, that is the substantial limitation under the plan. They get so much less for their damages in the NICA program. And this brochure does not say that. Instead, it suggests that they should get peace of mind for an unexpected problem, because although they can't bring suits, they get their compensation this other way, and it doesn't give a clue that the compensation is so severely limited. And I'm not suggesting that if you had a couple of sentences that said there's these benefits that you can't get under NICA that you could get under a malpractice suit, that all these families are going to drop out of NICA. Most of them probably would stay in the program, but they're entitled by the statute to hear that there is a major, major difference in what they can recover. And then at least some of them will inquire further and make an informed choice of whether they want to stay in the NICA program or think about switching doctors so that they preserve their common law rights. We're talking about children who aren't even born yet.
What about the Jackson case where a panel of this court said that this same pamphlet contains a clear and concise explanation of the patient's rights and limitations under the NICA plan as required by the terms of the statute?
The Jackson case worries me some. It certainly says that. But if you read the whole opinion,
wouldn't we have to go on Bach to do anything other than find that this brochure does meet the statutory requirement of a clear and concise explanation of the limitations under the plan?
I don't believe so, Your Honor. I think it's clearly dicta. If you read the whole opinion, what the opinion is concerned about, the only issue that's in the opinion that's discussed is whether the receipt for the brochure or the brochure itself has to name the identity of the physician on whose behalf it's offered. That's the only issue of the contents of the brochure that was being discussed in the opinion. And for that reason, I filed a motion to ask the court to take judicial notice of the briefs in the Jackson case. I attached certified copies to my motion, and the courts granted the motion. And, Your Honor, if you look at those briefs, no party briefed the issue of whether the substantive content of that brochure failed to meet due process or the statutory requirements that it include a clear and concise explanation of the limitations of this plan. It was not briefed, and if it was, you could expect the appellees to bring it up.
Mr. McMillan, speaking at least for myself, I agree with you that the language that's in that opinion is troublesome, but I would also agree with you that I went back and read the briefs in the Jackson case, and I agree with you that the adequacy of the language of the brochure was not an issue in that case. And that line seems to have been picked up by a finding from the ALJ, where the ALJ said the brochure contains a clear and concise explanation, and that just sort of got carried forward in the opinion, although it wasn't central to the case. You correctly described that case. So at least speaking for me, I agree with you that although the language of the case is fairly broad, I think it is dicta and it's not controlling.
I would hope not, and if it requires an in-bank consideration, I'm not familiar with the procedure, but I'll file a motion to request it or whatever is necessary, because it's not discussed at all by the parties on appeal. So it wouldn't be appropriate for the court to have decided it on that issue or during that case. I'd like to reserve the rest of my time unless Your Honor has another question. Thank
you. May it please the court. My name is Wilbur Bruton, along with Harvey J., who represents Florida Hospital. I'd like to use no more than 10 minutes of my time so that he has 10 minutes of the time. Your Honor, in the Jackson case, and I didn't bring it with me, and I apologize, but I thought this was an issue on reconsideration when this opinion was rendered. But regardless of that, the ALJ's opinion was affirmed, and the ALJ found as a matter of law that, and he has on numerous occasions, and we've been before this court on several of these, but not raising those issues, that he's found that the brochure contains a clear and concise statement. And let me just...
Well, but first of all, you're not suggesting that the ALJ's opinion has any precedential authority on our court, do you?
No, I'm not.
And in looking at Jackson, looking at the opinion in Jackson, it says right in the opinion, the parties stipulated that Jacqueline's claim was compensable under NICA, and the only issue to be resolved was whether adequate pre-delivery notice had been given to Mrs. Jackson by PAF concerning its participation in NICA. In other words, did she get the notice?
Or didn't she?
Or didn't she? It really, the fight was not over what the notice said. The fight was whether or not she got the notice, and I think the case clearly says that. So I went back and I read the briefs, and although, I certainly admit, as I just told opposing counsel, that Jackson says that the brochure contains a clear and concise statement. I think that's just kind of a line that got in there because it isn't germane to the holding. The holding of that case strictly turned on did she or did she not get notice, not what did the notice say.
Well, I'm here to convince you today that it does contain a clear and concise
I'm not
statement.
suggesting that you can't convince me of that. I'm just suggesting that I don't think that Jackson is going to convince me of that.
Okay. Without waiving that, let me go forward. The exclusive remedy states specifically in the brochure that the law provides awards under the plan are exclusive, and that means that if an injury is covered under the plan, the child and its family are not entitled to compensation through malpractice. It explains the difference. You cannot sue. In addition to that, the ALJ found in this particular case that the law does not require NICA to provide legal advice, if you will, to tell people potential civil remedies. We agree with that issue because contrary to the appellant's assertions, the NICA brochure does inform the reader that, one, the injury must be caused by a specific type of injury, oxygen deprivation or mechanical injury, that the injury must be permanently and substantially mentally impaired and physically, that only injuries under the plan are covered, and that if an injury is covered by the plan, the child and his family are not entitled to compensation through malpractice insurance. Now, there are no facts in the record that support appellant's position in his brief that only fault cases come before NICA. But Your Honor, from a practical perspective, where we are in this particular case is that that for all practical purposes, we would be here today if we weren't arguing this issue as to did we leave another issue out that might have been specifically unique to any particular potential plaintiff. And I don't think that's what the statute mandates. It says that you got to tell a person enough under the Galen case that they can make an informed choice or an informed decision. It does not say, the statute does not say that we have to give legal advice to potential petitioners. We've told them enough, and if that's not enough, at the end of the brochure, it says if you need more information, call us at such and such a number. You can check the website. You can understand exactly what's there underneath the benefits section. But from a realistic perspective, we think we've complied with the law. We think it's clear enough so that a person receiving it would be able to say, geez, I need to inquire further. I might need to talk to Mr. McMillan in reference to whether or not I should change my doctor and go forth. But I do not believe that the state placed upon NICA the duty to follow through and give legal advice to each petitioner. And that's what I think the position is, Judge Orfender. Any questions?
Thank you, counsel.
May it please the Court. Harvey J. on behalf of Florida Hospital, Lock Haven, and Dr. Natasha Knight. Certainly, on behalf of those three parties, we agree with the argument that, in fact, the ALJ was correct in finding that the brochure met the legislative mandate. Additionally, that the brochure was in accordance with the statutory language. I believe respectfully that the ALJ did an excellent job of going through and analyzing the statutory principles applying to the court's analysis. under the statute of the brochure, saying that courts are not at liberty to add words, to modify words, and looked at in context. This language talks about clear and concise explanation of a patient's rights under the plan. That phrase is critical because under the plan means the NICA plan, and the sentence immediately before talks about the obligation of the hospital and the physician to provide notice as to the limited no-fault alternative. Well, the no-fault alternative is the plan. So you have the sentence before talking about the plan. Galen actually talks about that in the Supreme Court of Florida's decision, and then the successor sentence also talking about rights and limitations under the plan. Mr. McMillan's proposition in regard to what should be contained would lead to a quagmire of things, as Judge Monaco pointed out. Perhaps could occur that verbiage not being included, verbiage beyond what the legislature mandates, verbiage that would need an attorney every time to evaluate. So we submit that the ALJ was correct in finding that the brochure met the legislative mandate. I'd like to move on now to our cross appeal, and the cross appeal for the court's clarity is on behalf of Florida Hospital. The ALJ did find that Lock Haven and Dr. Knight did give notice under 766-316. It is a position of Florida Hospital that proper notice was given. And the critical aspect here, and
But isn't that a factual finding?
Very good question, Judge Monaco, and I believe that exact question was resolved by the Kurtz case. It's a case we talk about in our brief. What happened in Kurtz was an alleged failure to give notice under the UM statute, and it was a bench trial in St. Johns County in front of Judge Weinberg. Judge Weinberg, sitting as the fact finder, made a determination that notice was not given, that the insurer had failed to meet its burden. On appeal, this court, Judge Cowart wrote the opinion, this court reversed as a matter of law and remanded to have judgment entered on behalf of the insurer. And the whole issue in that case was whether the insurer was entitled to a rebuttable presumption based on their standard routine practice. That's exactly what we have here. And I would like to take the court through the second visit. I'd like to start there, the second admission, which is October 7th.
But
Yes, sir.
I understand the earlier case, but if this is a factual finding that the administrative law judge said, I find as a matter of fact that they weren't given notice, and if the standard of review is abuse of discretion under those circumstances, is it?
On the factual question, I believe it would be, Your Honor.
And I fail to. I mean, I don't understand how the rebuttable presumption comes into this, unless we're talking about an absence of evidence.
Well, going back to Kurtz, we would submit that we met that rebuttable presumption. The rebuttable presumption was never rebutted, and that was the holding of Kurtz that the insurer.
But you're assuming that the rebuttable presumption came into existence. I think the problem that you've got is that the hearing officer concluded that you had not established, not put forth sufficient evidence to create the presumption. I mean, he basically said, these are all the things that your evidence was, these are all the things that normally happened, and your witnesses came in and said, yes, we always do these things, and yet in this case, for whatever reason, these things weren't done. And I think that he came in and said, well, this may be your normal practice, but your normal practice is to document all of it, have receipts for all of it. None of that exists here. So I think your problem is not that the normal business practice can't be competent evidence. He concluded that you had not put on evidence that would support that rebuttable presumption.
As a matter of law, as to the first part of that, Judge Orfinger, which was Ms. Miranda saying that I am certain, confident, I followed the routine practice. And my routine practice was to always give the NICA brochure to the patient. That stands unrebutted in this record, that she would have followed that routine practice.
But she also got signatures and filed things in the patient's file, none of which happened here.
Well, as to the seventh, Your Honor, what we know from Ms. Miranda's testimony is she would give the brochure and the signature form to the patient, who would then give it to the L&D nurse, not back to financial services. And you're correct, that signature form is not in the record. But as to the threshold point of her saying, I gave this notice based on my routine practice to this patient, that is unrebutted.
Well, it's also, isn't that a matter of credibility for the trial judge to determine? Maybe he didn't believe her. Well, the administrative law judge. Well,
he actually made the finding in his final order that she followed her customary practice, and her customary practice was to give the NICA form. So if you look at the front end of that, which is exactly what we have in the Kurtz case, the notion of providing that notice to the patient, and the patient says, I simply don't remember. So we have a neutral with the patient. We have the hospital establishing...
Did she say, I don't remember, or I don't think I got it?
Well, she initially said, I don't think I got it. On cross-examination by Mr. Bocchino, she very clearly said, I don't recollect, one way or the other. And she said it several times, Your Honor, as to both visits, the 29th and the 7th. So if you have a neutral for Ms. DIANDERAS, and you have the hospital establishing, as recognized by the ALJ, that Ms. Miranda gave the brochure to Ms. DIANDERAS. Based on Kurtz, the hospital would be entitled to that rebuttable presumption, which as a matter of law was never rebutted. Now, the ALJ talks about TAB, the TAB case from the 1st District, and respectfully to the 1st District and TAB, I think TAB overlooks Kurtz. It also overlooks the Supreme Court's decision in Brown, as well as other decisions from the appellate courts. That is that routine practice can create a rebuttable presumption, and it is our position that as to that threshold matter of actually giving the form to the patient, the rebuttable presumption was established, unrebutted by the patient, and therefore, as a matter of law, based on Kurtz, the hospital is entitled to a finding of notice. The other interesting thing about Kurtz is the court actually talks about, Judge Cowart talks about in his opinion, that the fact that other things were received by the insured in that case was indicia that the protocol was carried out. And what we have in this case, you're right, we don't have the signed form as to that October 7 admission, but we have everything else signed by the patient. And it's fairly compelling to me that Judge Cowart and Kurtz finds that the fact that everything else is there is a pretty good indication that the policy, the procedure, the routine was followed. And because there was no rebutting evidence from the insured in that case, as a matter of law, the insurer was entitled to win as a matter of law. And it would be our position on the cross appeal that based upon Iris Miranda having given this form to the patient, and the patient saying, I don't remember if I got it or not, that in and of itself...
Well, she also didn't remember actually giving a form to her, right?
No,
what she said was, this is my routine. I don't have a specific recollection. Is she the person that remembered the first name, the unusual first name of the mother?
No, sir. Yes, sir. That was the other. But you're right, Your Honor. She did not have she didn't remember with specificity that she handed this form to this patient. But again, Kurtz talks about the routine practice, and again, to quote Judge Cowart, the insurer presented no evidence that the practice was followed in the particular instance. So in Kurtz, just like this case, they didn't have evidence that they mailed out that form to that insured on that day. They simply presented evidence of the practice, which is what Ms. Miranda testified to.
Footnote 9 of the ALJ's order talks about this issue a bit, and the ALJ concluded that The hospital is of the view that the absent forms don't evidence a breakdown in routine, but simply a loss of the forms. However, if the practice was routine, one would expect the nurse to request the form when Mrs. DIANDERAS entered on October 7, since the form was required and had to be placed in the patient's chart. And it is unlikely that such an important form would be unaccounted for on one occasion, much less on two occasions. Rather, a more likely explanation, given that Mrs. DIANDERAS evidenced no reluctance to sign any form the hospital presented to her, is that neither the NICA brochure nor the acknowledgement form was provided. That seems like a reasonable conclusion that the hearing officer could draw from the evidence that he was presented with.
A back-end conclusion. The front-end conclusion, Judge Orfinger, is the giving of the brochure. The back-end conclusion is the signing of an acknowledgement that they received it.
Well, but you know, when you think about routine business practice, you know, the routine business practice in this particular proceeding is composed of a number of different steps. It's not just one step. And here, the best that you've got to offer really is you've got the nurse Miranda, is it?
Financial services, yes.
You got Mrs. Miranda saying, I don't remember this patient specifically, but my routine practice is, of course, to give this form out. Now, if the hospital actually followed its routine practice, that form would have been given to labor and delivery, that form would have been in the chart, that form would have, a lot of things would have happened, none of which happened. So it seems to me that in establishing routine business practice, you maybe took the first step, but it seems like there are other steps that you had to accomplish before you could actually establish that practice. I don't think step one gets you there.
There's a break in the chain, Your Honor just talked about. The break is the patient, because the patient was responsible for giving that acknowledgement form to the L&D nurse. So Ms. Miranda, based on her testimony, provides the brochure to the patient, and her testimony was, I've never missed one patient, but she gives the brochure to the patient as well as the acknowledgement form, and then we rely on the patient after sitting down in the waiting room to give that acknowledgement form to the nurse.
So your routine business practice is that this most critical form that you're relying on right now is placed into the hands of a woman that's in delivery who, I don't know about you, but I know at least the first time my wife was in labor, it was kind of a nerve-wracking experience, and she's supposed to be charged now with the responsibility of maintaining the hospital records, and the fact that that record doesn't exist is somehow her fault? That's a rather remarkable file-keeping methodology.
In no way am I disparaging the patient for not having passed that along. I'm just saying...
So your explanation is, if it didn't make it to the file, the only reasonable explanation for that is a screw-up on the part of the mom. It is impossible, under these circumstances, that the hospital could screw up.
Well, the hospital, candidly, Your Honor, would have an obligation to ask for the form, the L&D nurse, on the back end. So I guess what I'm saying...
I guess what that leads us to conclude is it's equally as possible. I mean, if you're saying that form never made it to the L&D nurse, then the L&D nurse obviously would have been on notice and say, well, gosh, we can't deliver this baby. Put things on hold here while we go get this form. You're having a hard time with me on that one.
The key is the notice.
Counsel, finish up your time.
Just briefly, the key is the notice. The form allows us the rebuttable presumption. The form complies with the statute as far as giving it to the patient. Thank you.
The police court. It's been argued that the Peace of Mind brochure has a phone number and an address where the patient can call for more information. If the statute says the brochure shall include a clear and concise explanation of the patient's rights and limitations under the plan, They can't just give a brochure that says, there's this program, call, and we'll tell you what the rights and limitations are under the plan. The statute requires that they be clearly and concisely explained in the brochure.
Mr. McMillan, does this case really come down to the question of interpreting the statute, and do we believe that when it says limitations under the plan, that means the limited compensation that is available to you per the plan, or does it mean that plus what common law elements of damages you might be waiving? I mean, is that really kind of where you and NICA disagree on this case? It's just that.
Yes, Your Honor. That is exactly our position. The substantial limitations of this plan for these families are that they get so much less. The brochure doesn't say that, with a simple explanation that there are elements of damages such as these 4 or 5 things right from the jury verdict form that you don't get.
But I mean, there's a whole lot of things. I mean, for example, when somebody comes to work for your office and they're covered by comp, they're giving up a lot of common law remedies. You're not required to tell them anything other than have that little poster on the board that says, I've got workers' comp in the event that you're injured. If you sign up for a PIP, which you're required, well, I guess right at the moment you may not be required, but back in January you'll be required again to have PIP coverage, which significantly limits your common law damages. You're not required to do anything, you're just stuck with it.
Yes, sir. I'm not familiar with comp or PIP requirements, but the NICA statute says the brochure shall include the rights and the limitations. And they must have meant something by the limitations, and the reality is the substantial limitation is how much they give up. And we're talking also, the difference in the programs may be that we're talking about a mother giving up something for a child that's not even born yet. She has no clue that we're talking about these severe injuries or just what the effect is. At least with a clue under the brochure that they're giving up something, they'll have an opportunity to consider whether they want to do something different. We're not asking the court to declare the NICA plan unconstitutional. In fact, we're asking the court to require the brochure to include what the statute says, so it will be constitutional when applied to these families. Ruling in our favor is not going to open up the floodgates of litigation. Any family NICA's been around a long time. The families that are already in the program have clearly waived any argument about it by entering the program and accepting benefits. NICA changes the brochure from time to time, sends it out to its members all the time, all over the state, so they can make a few basic changes pointing out the substantial limitations are that they're giving up a lot of damages, and get it out for the doctors to give to the future deliveries. And as I said, it may be that most of the families won't change. Some probably will, and they all have a right to. And it's our position that the statute and due process compel this result. Thank you.
Thank you. Very well argued. Thank you, gentlemen.